Bifurcated fee arrangements are a matter of great concern to bankruptcy courts throughout the entire United States. What is a bifurcated fee arrangement, you ask? Well, unless you are a consumer bankruptcy lawyer, you probably don't know. But let me say first that a bifurcated fee arrangement is one proposed solution to a problem created in the year 2004 when the Supreme Court handed down the Lamy case. That was where the justices said that a lawyer cannot compel a client to pay fees after filing a Chapter 7 petition if the retainer agreement, that is to say, the obligation to pay the fee, arose before bankruptcy. Now, there was an easy solution to that problem. The client simply pays the entire filing fee and the lawyer's fee before filing a Chapter 7 petition. Oh, but that in itself is a problem because many people who are eligible for Chapter 7 are just so broke they do not have the $1,500 to $2,000 to pay the filing fee and the lawyer's fee. That's where bifurcated fee arrangements came about. In essence, what it means is that the client pays maybe a little bit, perhaps nothing, before filing a Chapter 7 petition, but then pays everything afterwards. The smart consumer lawyers in the country started drafting retention agreements to accomplish just that. And initially, bankruptcy courts were quite reluctant to go along with the idea, but as time passed, the lawyers got more creative, got much better at drafting these agreements, and slowly but surely, bankruptcy courts began, to some degree or another, to approve these bifurcated arrangements. The issue is now such a hot item that just within the last week, I have written 2 stories on my column on the ABI website approving these bifurcated arrangements. One was by Bankruptcy Judge Laurel Isikoff, the Chief Judge in Miami, which is the Southern District of Florida, and the other is from the 8th Circuit Bankruptcy Appellate Panel. These decisions both gave, shall we say, qualified, if not detailed approval to what works as a bifurcated arrangement and what doesn't. Ultimately, the solution to this problem needs to come from Congress. There are some smart people right now who are drafting legislation, but who knows whether it's ever going to pass Congress and be signed by the president. Meanwhile, why don't we simply modify the bankruptcy rules or adopt local rules that will tell what works and what doesn't work as a bifurcated fee arrangement? But the problem with that is these bifurcation agreements involve so much substantive law, not only the bankruptcy code, but also state ethics rules, that really a rule would be, I think, more substance on law than on mere procedure. And rules shouldn't decide issues of substance, so therefore, I'm thinking that local or bankruptcy rules are not going to work. I really like what they did in the Southern District of Florida because Judge Isikoff got together with all of her brother and sister judges in the Southern District of Florida, and they all approved the opinion that she handed down, and that had the effect of telling lawyers everywhere in Southern Florida what works and what does not work as a bifurcated fee arrangement. Well, pay attention to my column, Rochelle's Daily Wire, which appears every day on the ABI website, and we will be reporting more and more of these decisions as they come down. Meanwhile, as I said, I suppose districts everywhere ought to think about judges getting together, writing an opinion that'll be a test case telling lawyers what worked and what doesn't work. I am Bill Rochelle, the Editor-at-Large for American Bankruptcy Institute. I will return same time next week with something else I hope that's interesting from the world of bankruptcy. Until then, good day.